The New York AG has replied to the joint motion of Trump and Knight Specialty Insurance regarding the adequacy of the $175 million surety bond that Knight Specialty Insurance issued. This is the bond for the appeal of the civil fraud verdict. It had been reduced to $175 million by the appeals court, which was a major win for Trump. It took 4 videos for me to describe just the findings of fact in that civil fraud verdict. I doubt a single Trump supporter has read it. Some of the issues are summarized more briefly in, quote, background on Trump organization properties and fraudulent schemes, end quote, which is available for online viewing. I'm not getting into those facts in this video, which just focuses on the surety bond issue. The New York AG has requested that the bond be rejected. It would be a big step for the judge to do this. A more likely outcome, at least if I was sitting on the bench, would be to require changes in the pledge agreement that would give Knight Specialty total and exclusive control over the collateral, then require it to convert any and all assets that fluctuate in value into a Treasury money market fund, and then prohibit any changes in the asset class, which would be the Treasury money market fund, until the litigation is resolved. Those changes would solve most of the issues raised by the AG, and she does raise some sound legal arguments, in my opinion. The New York AG claims that the Trump and Knight Specialty Insurance Company have the burden of proof to justify the adequacy of the surety bond under CPLR Section 2501. The primary legal contentions, I'm not going to get into all of them, just the ones I view as primary, are as follows. 1. Knight has only $138.441 million in policyholder surplus, whereas the New York statute requires no more than 10% of that surplus issued for one bond. The maximum allowed for one risk is consequently $13.8 million, not $175 million. The Knight Specialty Insurance bond exceeds that limit by $161.2 million. The value of the collateral can be added to the Knight Insurance policy surplus only when the surety has been transferred, has had the collateral transferred to it and is now held by it. This has not happened yet. 2. Knight currently lacks exclusive control over the collateral, and the DJD revocable trust can withdraw from that account and trade in it, which means that the collateral cannot be added to Knight Specialty Insurance policyholder surplus, at least as the pledge agreement is currently written. It would have to be changed to give Knight Insurance total control over the collateral. 3. The collateral may not be in cash as claimed by Trump and Knight, but in assets that may fluctuate in value. And that's the kind of issue that the judge will address in next week's hearing. 4. Trump can substitute stock as collateral. And Knight, and that kind of asset can fluctuate a great deal in value. It raises an issue whether the DJT stock, which is fluctuating wildly in price, can be substituted for whatever cash or cash equivalents is now part of the collateral in whole or in substantial part. 5. The reinsurance agreement between Knight Specialty Insurance with the Cayman Island domiciled parent Knight Insurance Company is not trustworthy, according to the AG, and is frowned upon by New York courts. And New York law, according to the AG, requires that regulatory approval for reinsurance agreements between affiliates is required under the Holding Company Act, which has not been done here. The filings made by the surety with the New York court have been described and can best be described as sloppy and incompetent. The first filing was rejected by the clerk. The court didn't even get involved in the first rejection, for failure to include documents required by law to be filed with the surety bond. The second filing included documents that were required to be filed and were not filed in the first attempt, but then had a wrong signature page on the pledge agreement, as I pointed out in my prior video on this subject, which I will link in the more column.